Welcome to another episode of the Profitable Home Services Podcast. Once again, I'm so glad that you chose to join us today. As always, we've got another exciting topic to bring you. This one, we're going to be talking to somebody over in the legal area. Now, don't leave. Hold on. This is good stuff. Promise. Remember the last time I told you that? It was great stuff. I know it's not as fun as marketing or some of those kinds of topics, but this one could save your business. I know, because coming at it from the accounting standpoint, I find my clients making these same types of mistakes over and over and over again. And when they get caught, I'm not saying if, when they get caught, the penalties are humongous that they end up paying, plus a lot of back tax, and it can cripple, if not actually destroy your business, depending on how long this has been happening and whatever, which one of these items that they catch you on. So with that, please join me in welcoming Philip Siegel, who is an attorney, and we're going to be talking about some of the top mistakes that I see home service businesses making. I'm sure Philip sees them all the time since he's working in that realm. So stay tuned. We're going to take off and roll, and welcome, Philip.
Hey, Dan, thank you for having me.
I'm so glad that we found your name as we're trolling other people's podcasts. And hey, any of my guests listening, if you know of people that would be great to be on this podcast, reach out to us. We're always looking for wonderful podcast guests. And so we found Philip by trolling other people's podcasts, which we do quite often. And when we find a good topic, it's like, ooh, we need to get that person over on our podcast. And so today, Philip, I want to talk about some of these really important mistakes that we see. And I'm going to caveat that is most of the people in the home services industry came up through the ranks. They started out working for somebody doing whatever it is, whether they were a roofer, or a plumber, an HVAC person, whatever it was. And eventually they decided to go out on their own. Now, there are always a few people that didn't come up through that route, but most of them seem to. And so they're really good at what they do, but nobody possibly has really enlightened them on some of these rules that just kind of sit out there quietly until they bite you. And one of those I want to start our conversation off is the difference between an employee and an independent contractor. Because it would be great if we could put all of our team on as independent contractors and not have to pay payroll tax, and see if we could get out from having to pay unemployment and workers' comp and all those things that come along with having an employee. But you're going to say, no way. So talk to us a little bit about what's the difference between an employee and a really, truly an independent contractor.
Yeah. So, Diane, the question is timely here on the misclassification issue as it's referred to, because, here we're just past 100 days under the Trump administration. We really don't know what's going to happen with the rule. This issue has become somewhat politicized. To go back under the Obama administration, the Department of Labor at that time put out a memorandum that basically said, we're going to interpret this law that anybody working for an employer is an independent contractor, and you have to convince us that the person working is an employee, tipping the scales in favor of classifying someone as an employee rather than as an independent contractor. Excuse me. The Obama said everybody is an employee
Right.
if they're made to work or suffer for the employer, and rare is the instance where we have a person properly classified as an independent contractor. Trump 1 comes in, and they significantly, and this is an important point, because here Trump is now the president, his Department of Labor is just getting settled. We don't know what's going to happen, but we can look to his earlier term. And what they did was they took that bar that President Obama had put up here in terms of properly classifying a worker as an independent contractor, and Trump basically significantly lowered the bar, focusing on whether, one, the level of control exhibited by the employer vis-a-vis the worker, and number two, core factor as it's referred to, was whether that individual worker has the opportunity for a profit if they perform efficiently, and similarly, if they're inefficient, do they potentially suffer a loss? And those two core factors were, in practice, easy to clear. So under Trump 1, to classify someone as an independent contractor didn't take a whole lot of argument. When we were engaged to look at that analysis, and again, really important point I'm making here because it highlights what changed under the Biden administration. Under Trump 1, when we were asked to explore the issue, I focused exclusively on the employer. My questions, my interview was with the employer, and the questions, surround, of course, that relationship. And based on the responses we got, we gave a legal opinion. Well, President Biden comes in and, of course, shifts that bar back to being difficult to argue someone's properly classified as an independent contractor. And President Biden, and this is the rule as we speak today. President Biden had introduced a rule that looked at a number of different variables, not any one variable carrying any particular weight. But if you step back and look at those variables and how the Department of Labor was interpreting them, it basically comes down to whether the individual worker is truly engaged in their own business. And I just got done saying, under Trump 1, when we were engaged to perform that analysis, we focused our questions on the employer. Well, under Biden, that changed 180. We had to begin interviewing the worker, and it was focusing on the responses from the worker and getting them to convince us that they were basically independently established business, not economically dependent on the employer that was bringing the issue to us. And I will tell you, Diane, that that rule published by the Department of Labor, that was in March 2024, and in the ensuing months, primarily in my experience as a labor and employment attorney in the construction industry, wage and hour issues were really not the primary catch where people got caught. People were getting caught really, in my experience, primarily if they were under an OSHA investigation. The compliance officers asking questions about, a worker classified as an independent contractor, are they really running an independent business?
And I see them getting caught in an unemployment world as well.
Oh, great one.
The
Great
worker
example.
trots down to apply for unemployment. It's like, wait a minute, you're not on the roster of their employees. And here we go.
That's number 2. Number 3 would be a workers' comp claim. Someone claiming I was an employee and I want the benefits of that insurance. So where I was going with all this is under the Biden rule, and in my personal experience dealing with contractors that came to me concerned in light of that rule, I joke about it, but it was no joking matter. I mean, everybody was doing it wrong. It was rare was the instance where I had a worker convince me that they were running an independent business. I mean, it happened. I mean, if I handled 50 matters like that, maybe 2 or 3 were properly classified as independent contractor because clearly they were running an independent business. They had an office. They were advertising. They invested in trucks and vehicles, tools, materials, and equipment. They had several jobs going at once. They had an office where they were managing the various jobs. I mean, staff, it was clearly a business, as opposed to the typical company that called me in the home service arena. It was like, Philip, we have a guy that's just doing all of our sales, or all of our installers are independent contractors. And okay, you want me to tell you whether you're properly classifying them as independent contractors? I need to speak with them, and I need them to convince me that they're running independent businesses. Before we even got to that interview, though, a threshold question I asked was to each one of those service providers, are these guys working for anybody else? In almost all those instances, the answer was no. No, that they're only working for us. We bring them from job to job to job. And it's like, okay, well, I really don't need to interview them. You're doing it wrong. If they're not working for other people, it's tough to argue that they're running an independent business, not economically dependent on you, client that's called me with the issue.
Right.
So, and the other common scenario is the guy who says, Philip, all my sales folks, our installers are our employees, but our salespeople are all 1099. Well, that salesperson could be properly classified as an independent contractor if they're out there doing sales for different companies in different geographical areas, maybe different trades, running their business from home behind their computer, that begins to look like a properly classified individual. On the other hand, in almost all cases, it was like, no, this man or woman is only selling our work. And that was actually the more common scenario. And, I have to explain, you can continue to pay these people if they fit within a common exemption that is out there is the outside sales exemption. And if these people are really doing outside sales, you can continue to pay them 100% commissions. And if they fit within that outside sales exemption, there's no minimum wage or overtime requirement, but they do have to fit within that exemption. And that's something all of these companies explore. But ultimately, to come back to where I started, Trump is now in office, and I don't claim to be able to predict the future, but it's a different Department of Labor. I mean, interestingly, Diane, here we're just on this call. I've got my computer up, my email up. I just got my first email from OSHA under the Trump administration. Under Biden, OSHA was issuing emails weekly, at least.
Wow. Wow.
So it's a different, with a different party in the White House, I expect a less aggressive Department of Labor. And I do expect the Trump administration to get around to putting out their own, going back to similar on what was Trump 1, rescinding the Biden interpretive guidance memo on this misclassification issue and reinstituting an interpretive guidance memo that, again, has the effect of lowering that bar, making it easier for employers to successfully and correctly classify someone as an independent contractor. I really anticipated they would have gotten to that in the first quarter because, the misclassification issue, joint employment, there are a couple other OSHA initiatives that the Biden administration was pushing out. The HEAT standard, your audience might be familiar with as being another one. While the Trump administration certainly pumped the brakes on all of that, they haven't come out and done anything, that's different. And I would have almost expected that in the first quarter, but I'm guessing, maybe we'll see something by the end of June.
Probably, yeah.
So these companies that are bringing the issue to me, and we're reaching the end of the analysis, and it's like, okay, you're doing it wrong. A lot of companies are taking right now a wait and see approach. Before we go and start making people employees that are independent contractors, let me see what the Trump administration decides to do on this issue, kind of playing it out a little bit.
Yeah. But let me say, generally, if you've had the same person working for you year after year after year as an independent contractor, and you're the only person he works for, more than likely he's going to be an employee.
Yeah, I mean, the other way to look at that, Diane, and I'm about to give it to you from the wage and hour auditor's perspective. Of course, I'm always representing the employer, defending against these things. But the wage and hour auditor would say to the company that has all of their work done by independent contractors, how are you operating? If with no employees, how are you operating? If the business cannot run and this is one of the factors under the Biden misclassification rule, is the work integral to the work of the employer? And so, for example, if you've got a home service company and their business is, blinds and drapes, and all they're doing is they're only operating through independent contractors, and the company wouldn't be able to do any blinds and drape work because it would be integral. I mean, these people are hired to do what the business is out there to the public is, how they're advertising themselves, as opposed to that same, blind and window dressing home service contractor, in their main office having a problem with their computers and engaging an independent contractor IT person to come in and get them back up and running. That IT person is going to be servicing several companies over the course of a day. Clearly the IT is not the business of the window, dressing, blinds, drapes, retail or home service provider. So that's a clear contrast. But again, I understand from having talked to people who are doing, the employer, Phil, everybody's doing it this way. I'm at a competitive disadvantage if I end up bringing these people in, and I understand that. So maybe you continue to do what you're doing until you're caught. And as you
Uh-huh.
open the show, it's only a matter of time because you'll have the disgruntled worker. We ran through a couple, Diane, the OSHA case, the unemployment, and I mentioned the workers' comp. It's also the worker. You stop giving work to that worker, and now they're not earning any work from anybody else. And now, they make a claim for overtime pay. They know they regularly work more than 40 hours. You weren't paying time and a half because they weren't your employees. Now they're saying, and Diane, I've been doing this a long time. The person that's going to do this, of course, is the one who asked your listeners, please classify me as an independent. I want to
Yes.
be the independent
I
contractor.
want to be. Yep.
Yeah, and I get that a lot. Well, do you want to accommodate the request or do you want to be compliant with the law? So, that's the rub there. But the person who says, I want to be an independent contractor, the work dries up, they're not earning any income, they meet someone at a cocktail party or having a beer at a bar, and they hear like, oh, maybe you could make a claim for overtime. You regularly work 50 hours, and you were an independent contractor. Well, they probably should have treated you as an employee. You can make a claim for all that overtime pay. It's a 2-year look back period. If this company was doing it wrong, they're going to owe up to 2 years worth of overtime, and the Department of Labor or plaintiff's attorney, they don't have to go to the Department of Labor with this claim. They'll seek to add a 3rd year look back if they say the violation was willful. And then whatever back wages are owed in these scenarios, they're often doubled. It's called liquidated damages. Your listeners probably hear liquidated damages and they think about a scheduling issue or delay claim. Here, it's an automatic doubling of the back wages that are owed. And the only way you avoid that, basically, is to be able to argue to the wage and hour investigator that you were relying on the advice of a professional and doing it the way that you did. Rare is that the case.
Yeah.
So the dollars do get somewhat significant. To your point earlier, it could put a company out of business because how many people, if all the workers were independent contractors, you're going to be facing a potential class action.
Yes.
And then, if you may think, well, they weren't working that much overtime, it's not that much money. Well, on top of the money, is the overtime. Excuse me, is the attorney's fees. The attorney who brings that claim gets their attorney's fees. And you can have an attorney in these cases easily spend $50,000 or more to recover $10,000.
Oh
And
my
they do
goodness.
get every penny of that
Okay.
$50,000. I mean, it'll be scrutinized, but that's not an absurd example. I don't know how your listeners are reacting. 50,000 in fees to recover 10 grand, that's actually reasonable.
Wow.
There's
So,
document reviews, there's potential depositions. I mean,
mhm,
there's a lot there.
yeah. So we need to tread carefully on this particular area. I know the IRS will sometimes take a different stance than the Department of Labor will. And then you end up with which one trumps the other one when you get into trouble with things.
Yeah, that's definitely a different rule, different analysis under the IRS.
Yeah.
I'm no tax expert at all. I don't dabble in that. And I will say, I mean, logically, you'd think that, the IRS would be talking to the Department of Labor, but Dan, I'm
Oh
doing this
no.
now.
Oh
Yeah,
no.
it doesn't. Well, I haven't had that experience. I have had the experience where a company gets under an I-9 audit and they're keeping their I-9s just in a personnel file that has wage and hour information, or again, to prove the point and why we're talking about it, some of these companies have personnel files for independent contractors.
They do. Yep, but they're still thinking they're independent.
That's one in the loss column for your listeners. But I say that because you'll have someone going through the file and they'll discover violations and they're calling their Department of Labor friend down the hall.
Yeah,
But I haven't had in my experience, I haven't found any overlap between the IRS and Department of Labor.
right. And I've been thankful for that from the accounting view, standpoint. I had a big messy Department of Labor issue with a client a few years back, and I was thankful that the IRS wasn't talking to the Department of Labor, because the payroll taxes on that stuff would have been outrageous on top of what they got socked for on the Department of Labor side, and that would have put that company out of business had both agencies ganged up on them. So
Yeah.
can be pretty bad.
Well, it
Yeah.
does happen, but my experience has been it's more like OSHA officer identifies the issue, we resolve the OSHA citation, and then then that OSHA person, which is under the Department of Labor, is calling their wage and hour auditor friend and saying, hey, I've got a live one.
Okay, live one.
Yeah, and that's been I mean, to this day, I do a lot of OSHA defense work, and I find that the just even with the change in administration, at least so far, here in the first 3-4 months, the OSHA investigators are still exploring the misclassification issue through their interviews.
Okay.
Um, with that said, I'm just thinking what OSHA matters have I had in the first 3 months. I haven't had anything. No, it's only been 3 months, but almost 4. I haven't had anywhere we gave information to the OSHA officer, truthful information, of course, that didn't paint such a pretty picture on the misclassification issue. But I haven't had any wage and hour audit following those OSHA inspections yet. It's probably too soon to conclude the Department of Labor is backing off, although I think, logically that makes sense.
That would be nice. Yeah.
Yeah. And again, just to reiterate and kind of close the loop on this, I do think we'll see, I thought it would have been first quarter, but by the end of June, I think we'll start to see some smoke from the Department of Labor about changing that rule, among others. Right behind it will be the joint employment rule.
And I think most home service businesses don't realize that these rules tend to change based on who's in the White House. You just think the
It's
rule
the
is set,
interpretation.
live with it.
Yeah, technically what it is it's the law doesn't change. It's how the law is being interpreted by the
Right.
governmental agency.
Right.
And again, tougher, logically, stereotypically, Democrat is in the office, it's tougher on the employer. Republican is in office, easier on the employer. And I think you'll start to see that here in the next few months.
And then we do have specific states that are doing their own thing as well.
Yeah, some states, well, yes. I make a point to stay outside of California.
Yeah, stay outside of
But I know,
California.
California has that ABC test, which makes it almost impossible to properly classify someone as an independent contractor if they're doing the work of your company. But
Right.
to your point, Diane, yeah, at the state level, it's out there too.
So be
But
aware.
almost all the issues I've handled involve federal Department
Yeah.
of Federal Wage and Hour audits.
So let's switch gears a little bit, Philip. A lot of these home service business owners, they end up taking jobs that maybe are far enough away that they have to spend the night out away, or at least their team has to drive for a few hours to get to wherever the job is. I see that a lot where I'm located up here in northern Idaho. They'll run over to Montana and do a job, and it'll mean that they'll spend the night rather than run back and forth because it's too time consuming to do that. They'll stay for 2 or 3 days, get the job done, and come home.
Yeah.
There's problems and there's issues and there's challenges with that. Let's break that one down a little bit, because I think that's so common in this industry.
Yeah, well, it's common in construction in general, and this is another one of those areas where I find contractors having the best of intentions are not understanding what the law provides, and it invites on this issue potential serious financial consequences. It is a wage and hour issue, and the problem is when again, it's ignorance. I mean, nobody, in terms of the clients we represent, are doing this intentionally. But I will say it's the most common wage and hour mistake I see, period, hard stop. Not understanding when this type of travel is, as the law terms it, compensable working time, meaning there is travel that counts as working time just as the actual production work is working time. all counting toward the 40-hour work week. And Diane, you present a scenario where, and it's the most commonly misunderstood category of travel. Anytime your listeners have an employee that is spending a night away from home in order to do work on behalf of the company, they are in the travel out to that job and the travel back home. It's not a function of distance. It's a function of where they sleep in. And if they're spending the night away from home, the travel out to the job and the travel back falls into the overnight travel category. Begs the question, and here's where the rubber hits the road. When is overnight travel considered compensable working time, time that cuts toward the 40-hour work week? Well, we're focusing on your listeners' non-exempt, typically hourly paid employees. Mm-hmm. And when do we have to pay them when they're driving out to this out-of-town job and when they're driving back home? Well, a typical scenario, a company is sending the crew out to the job together. And in most instances, the company is saying, hey, you're to meet at our office or at a designated location at a time certain. We will have the driver with the company truck at that location to take everybody out of town. We'll have one driver. The rest of you that are assigned to this project will be passengers. And let me first say, this person who's assigned the task of driving the crew out of town, this person is going to be working. I don't care when the drive leaves. And when the drive leaves is going to become important here in a second. The driver is working the entire time he's driving out and the entire time he's driving back. He's been assigned that task. He's bringing the crew to the job for the benefit of the employer. That person is working all of the drive. Let's focus on the non-exempt passengers. Well, here's the rule on overnight travel. It's considered compensable working time if any of that travel cuts across the company's normal working hours, even if it occurs on the weekend. So, for example, every company is going to have normal working hours. I mean, Diane, I've had companies hear me on this and they say, well, we don't have normal working hours. You do, and the Department of Labor will tell you after they review your payroll records. But let's just say the typical contractor, their regular working hours are 7 a.m. to 3:30 p.m. And this job happens to be a 5-hour drive away. So again, restating the rule for the passengers, they're considered working and they need to be paid at least minimum wage. You could pay a lower rate for compensable travel than you do for production. But the non-exempt employees, to the extent that travel cuts across their normal workday, they're on the clock and they're to get paid and it counts toward their 40-hour work week. And it might kick them into overtime. So if it's a 5-hour drive and this crew leaves on Sunday at noon, your typical hours are Monday through Friday, 7 a.m. to 3:30 p.m. And I told you it's a 5-hour drive. So they're going to be driving. They're going to be riding as a passenger from 12 until 5 p.m. The only part of that drive that cuts across normal working hours is from 12 to 3:30. So for those 3.5 hours, the passengers are on the clock. They must be earning at least minimum wage, and they're accruing time toward their 40-hour work week. From 3:30 to 5, that's outside their normal working hours. It's non-compensable, non-working time. If you wanted to save labor costs, you would conceivably tell the crew not to meet until Sunday at 3:30 p.m. And then the passengers for the entire 5-hour ride, all of it occurring outside normal work hours, none of it is compensable working time. Now, we do need to make sure while they're passengers, they're not doing any work for the company, reviewing plans, material, as long as they're just, they can be taking a nap. I mean, if they're just riding as a passenger and nothing else, and the travel is outside their normal working hours, it's all non-compensable, non-working time. The same thing applies on the way home. Let's say it's a job, maybe not typical, but just to prove a point, a 5-day job. So they're at that hotel motel, and then Friday afternoon they wrap up at 1 o'clock. and then the driver gets everybody in the truck and they start heading home. Well, you know what I'm going to say, from 1 to 3:30,
Yeah.
the passengers are on the clock and they're working and they're to get paid. If they didn't leave if they had worked a full day on Friday and left at 3:30, as unfair as it may seem, from 3:30 until 8:30 when they get home, none of that is working time because it all occurred outside normal working hours. And again, much like the misclassification issue, you don't pay for compensable working time. It becomes back wages owed. And in a lot of these cases, Diane, you add the time spent in compensable travel on top of their 40 hours that they actually did production-wise.
Oh, wow.
And now they're entitled to time and a half. You do this for a group of employees, you get that potential class action. Again, it's the 2-year look back, potentially adding a 3rd year if it's willful. And then if it's prosecuted by a lawyer, you'll have that attorney claiming, that they spent a ton on fees, trying to get there. So, and in this mistake here, in almost all cases, like I said to start it off, I mean, no one's doing it intentionally. The employees think they're handsomely compensated. They think their employer is great. They think everything's fair, but they're answering questions that are being posed by a wage and hour investigator. They're answering honestly, not knowing that they're implicating the employer while also, putting more dollars in their pocket. But in almost all cases, it's we're very happy with our employer. We think we're treated fairly, and yet the company's doing it wrong, and of course that's no defense.
Right. Wow. So many rules to be thinking about when you own your own business.
Yeah, that's a big one.
Yeah, I alluded to it earlier. You and I were talking before we went live. I heard you on another podcast and you scared me about the requirements on how to properly fill out an I-9 form. And that's what caused us to reach out and said, okay, Philip needs to come and be on my podcast so he can scare my listeners about I-9 forms.
Yeah, well, this one right now, there's a lot to be scared about right now in terms of I-9 and immigration, and I'm not trying to be political about it at all because what has happened is, well, let me say this. Back to Trump 1, I was regularly engaged by construction companies, commercial, residential, throughout the country to assist with the defense of an I-9 audit. Immigration's Customs Enforcement has just showed up randomly in almost all cases and announced that they were there to conduct an I-9 audit. And I had one going at any one time. It wasn't like I had multiple going at one time. It was like I finished one, the next one would show right up. I was always busy with it over that 4-year stretch. Diane, over the last 4 years, I can't think of one I-9 audit I defended, not a single one.
Wow.
And that's significant, not to pat myself on the back, but I do get out there on a national basis and I'm representing companies all across the country. And that's why I was doing all that I-9 work. So it dried up under Biden. Now Trump's come in and he's been very vocal about immigration, as we all know. To take it a step further, though, he's indicated he intends to, through Immigration's Customs Enforcement, conduct as many as 12,000 Form I-9 audits, during the balance of 2025. That's a ton.
That's huge.
I think under Biden they did like 500 total over the 4 years. I mean, really, the numbers are that striking. So anticipating these I-9 audits, they're not pleasant. I mean, and the reason why is because it shuts your company down for 3 days as you work to gather the I-9s. And if you're not taking steps proactively to make sure, one, you've got an I-9 on everybody that's been with your company hired subsequent to November 1st, 1986, when the law became law. And number two, you're making the necessary corrections so you're not turning over I-9s with errors. It becomes a colossal fire drill. And again, you got to really stop everything else you're doing and focus on getting things in order before the I-9s are subject to production. So I'm cautioning clients, and again, you can Google this. I mean, don't take my word for it. You can Google Immigration's Customs Enforcement under Trump anticipated Form I-9 audits. There's a ton published out there about it because employers are low-hanging fruit for this administration looking to get illegal labor out of the country. So, what I'm cautioning clients about right now is, one, it's a good idea to get ahead of this to avoid that fire drill and shutting down your company, to take time at a controlled pace, looking at your I-9s, determining where you've got errors and omissions, and then making the necessary corrections and making those corrections legally. There's a right way and a wrong way to make a correction on a Form I-9. And then, number two, right behind that, beyond just the corrections and omissions, through that process, you may learn you have employees that have been hired, since the law became law that don't have an I-9, and that's considered a substantive violation. You were potentially hiring someone that wasn't legal, so the penalties are a lot more harsh. No opportunity to correct a substantive violation. But again, you can show good faith by getting ahead of it. So I'm cautioning clients right now, review your Form I-9s. And I do that work, again, I'm not looking to sell anything, but I do that work across the country. And we're, again, at a casual pace, identifying correct errors on forms. We're going back to the employees. If it's a Section 1 issue, Section 1 issue can only be corrected by the employee. And we're having the employee make the correction. If it's a Section 2 issue, the company's taking care of it. But sometimes we're having to look for someone in the company that isn't in the main office. So, and that is why we want to do it on a controlled pace and not in the government's 3-day window we have once they show up to produce these documents. One thing I will tell your listeners, though, off the bat, in terms of the most common error on that I-9, I mean, there are several common errors. But one I see time and time again, and it is the silliest, Diane, but going back to under the Trump administration when I was defending against these audits, it's the date format. It's having to use a 2-digit day, 2-digit month, 4-digit year. Not providing the date anytime the date is asked for on the I-9 form. If you're not doing it in that format, it's a technical violation and it needs to be corrected. Silly, I mean, but that's what we got back. I mean, I don't want to come off here with some egg on my face, but back early in that Trump administration, it's kind of going through those Form I-9s and seeing, wow, a lot of these are done really well. No issues. And, we provide it to ICE and they come back and they've highlighted the dates. And, that's where I began very early in the Trump administration, recognizing that, wow, they're really picky. I mean, they want the date in the correct format. And, in their defense, the form itself signifies the format that the date is to be provided. It's just ignored. So that's been most frustrating for companies because it is almost, the error appears almost everywhere. And you do have to go back to employees in Section 1 where they're asked to provide the date 2 different times to get that corrected. And then for the employer, Section 2, you got the date of work, the date when the documents were reviewed, and the date it's signed. So there's plenty of opportunities to put the date in the incorrect format. The second most common example, and again, or mistake, Dan, the best advice I can give your listeners is, take your time completing the form. I get it's an annoyance, and there really was, over the last 4 years, not great reason to have to pay close attention to it. But now we know that those forms that were completed over the last 4 years are going to be subject to audit under the Trump Immigration Customs Enforcement Agency. So it bears going back and look and making those corrections. I will tell you this, though, the second biggest error, it's a Section 2 issue. If we're working with the form, the most common form in the most recent years would be the one that had an August 2023 revision date in the lower left-hand corner. At the top of page 2 of that form, there's a line for the employer to identify the employee, not just by last name, first name, and initial, but there's also a box right up there at the top for them to, the employer to identify the immigration status the employee put themselves in from page 1. And The common mistake is one, the employer hasn't identified that there's something up at the top that needs to be filled in before we get to the part of section 2 that solicits the information regarding the documents that are produced to prove employment eligibility and identity. So, that's another pointer. Your listeners who are going to go back and perform a self-audit of their I-9s, if you're going to self-perform it without going to an attorney, just make sure the person doing the self-audit is not the person that's been completing the forms for years, because that person may not recognize they've been making the same mistake forever. You need to set a clean eyes on that.
Right.
But in any event, if your listeners are going to go back and do that self-audit, I'm telling them now to focus at the top of page 2 on the August 2023 form. Was it filled out? Was it filled out in its entirety?
So on the date issue, can they go back and just draw a line through it and put the 4-digit? Or how do
Yes,
you have
Diane,
to
you're
fix
correct.
things
That
like
is the legal way. You're not going to you don't backdate anything on the I-9, but they would
Okay.
just simply if it was an error and not an omission, they would simply draw a single line through the date as it was originally, written, and then right next to it, on top of it, they're putting the date in the correct format. And then the next step is to both initial and date using today's date or the date of correction in the
Okay.
margin closest to where that error was corrected.
Okay. So it is correctable then.
It's a correctable. The only violation that's not correctable is the substantive violation. The most common one would be, and this is another important point for your listeners who are going to do that self-audit. If you're doing the self-audit and you get to section 2 and you see, section 2 has been completed in its entirety for the purposes of this hypothetical. So no information is missing. That's the point I'm making. But you're looking at the date that the employee started work and the date the documents were reviewed, and we can see that the documents were reviewed more than 3 days after the employee was hired.
Uh-oh.
That's a substantive violation. It cannot be corrected. You're subject to a fine for having done that, because the argument is this person may in fact be legal, but the argument from the government is they could have been illegal, and because you didn't do it to the 5th day, you could have been employing them for 2 days illegally, and that's why it's a substantive violation.
Oh my
For
goodness.
your client, for your listeners that are find that they've done that, my recommendation is, and it's Immigration Customs Enforcement's recommendation, to prepare a short memo, 1 or 2, however long it takes. It shouldn't take more than 1 or 2 sentences, that explains why it was late. And you're taking that 1 or 2 sentence memo. You might type up the memo, but the memo needs an original signature. You can't type the signature.
Okay.
Original signature and date, and you're stapling or clipping the memo to the I-9 form. And your hope is you've bought good faith, and there won't be any penalty associated with that violation. But that's really the best you can do.
Okay. Wow. So I hope you guys caught all that. Thankfully, with this being in a podcast format, you can go back and listen to it again. We are on all of the audio platforms as well as on YouTube. We'd love for you to go over and like us and subscribe to our channel on YouTube. But this has been great, and I want to say, Philip, thank you so much for coming on and sharing. I mean, you had a list of 10 and we hit 3. So
happy to come back and talk again, Diane, when you're ready for me. I don't want to ruin anybody's day more than I already have.
But we might want to do that. We might want to, circle back around and hit another 2 or 3 of them, because it's so hard when you're a business owner. You've got to keep everything rolling out in the field. You've got to keep your office turning. You got to keep the money coming in. You got to keep the bills paid. There's so much sitting on a business owner that this type of thing, especially if they don't have a good in-house bookkeeper who will kind of stay up on the payroll side of things, these are the types of things that get just kind of pushed off into a lower category. And then they don't
it's all good until it's not.
Until it's not.
Yeah.
And just in the years that I've been in business, I've seen some pretty scary things happen from the Department of Labor side, which is why I was so excited to get you to come on our episode.
Yeah. Well, we'll see where it goes, but let the dust settle on the Department of Labor. We'll see. I'm happy when news is published. Happy to chime in and give you my thoughts as well. I really appreciate the opportunity, Diane, and thank
You
your
bet.
listeners for listening.
Yeah. Before you go, I have our magic question that we ask at the end of every episode. And let me get my little bucket up here, our little proud to be
Okay, this is
profitable
pressure,
bucket.
but go ahead, try me.
Throw some money in there. Philip, we're always looking for a unique or an unusual profit leak. And I know with you working with these kinds of businesses, you've probably got a good story.
So immediate reaction, the the company that's calling me because they had a salesperson leave, and this person is now working down the street calling on your listeners' customers.
Oh,
That's
no.
profit leak. How do you nip that in the bud? Well, unless this person that's left your company is slandering your business and taking your customers, there's nothing illegal about that competition. But you can close that profit leak by having a properly drafted, legally enforceable non-compete or non-solicitation of customers agreement. Diane, that's one of my top 10 mistakes, not having one of those agreements, or I often say, shutting the barn door after the horse has already gotten out. But I'll leave that there. Maybe that's a cliffhanger for the next time.
All right. Thank you for sharing that because I would not have come up with that one. So very good. I love it when our guests give us one that I'm not necessarily thinking about. So very good. So thank you, Philip. How can our listeners reach out and find out more or say, Philip, help? We're in
Well,
trouble. How do they get a hold of you?
I appreciate the opportunity. My direct line at my office, phone number, never hesitate to call, 404-469-9197. That's 404-469-9197. My email address, it's pjs@hpsslaw.com. That's pjs@hpsslaw.com. My firm is Hendrick, Philip, Salzman, and Siegel. That hpsslaw.com is our website. You'll find my bio on there as well. And again, we are a construction boutique firm. We do nothing but represent contractors across the country. It's our niche practice area, and we've been doing it since 1981.
Thank you. And for listeners, those of you who are listening on the go, his contact information will be down in the show notes so that you can grab it when you have a chance to pull over or take a second look at this. So Philip, thank you again for coming on and talking about this. And I know the listeners were sitting on the edge of their seats because I'm on the edge of my seat thinking about, oh no, from the accounting side, is there anything here that I wasn't aware of? As we work together to try to help keep these home service businesses profitable and keep their profits from leaking out from unnecessary fines and penalties and back wages and things like that, because those are huge profit drainers. So let's keep our people away from that arena. Thank you again, Philip. Thank you, listeners, for listening in, and we will catch you in the next episode. Bye-bye.